And pursuant to Standing Order 1082, we're going to continue our study of remediation agreements, the Shaw Cross Doctrine, and the discussions between the Office of the Attorney General and government colleagues.
From the Privy Council's office, Mr. Michael Wernick, the Clerk of the Privy Council and Secretary to the Cabinet. Welcome, Mr. Wernick.
Point of order.
Point of order, Mr. Cooper, yes?
Thank you, Mr. Chair. I would request once again that the witnesses be sworn in. Clearly, the testimony of Mr. Wernick, the last time he appeared before our committee, is in many areas inconsistent with the testimony that Ms. Wilson-Raybould gave. Given the gravity of the allegations and the very detailed testimony of Ms. Wilson-Raybould, I think that in the circumstances it is appropriate that both of the witnesses be sworn in. Thank you, Mr. Chair.
Mr. Cooper, I'll repeat what I said this morning, that no witness has been sworn in this committee for the last 25 years at least. That witnesses are required, and I'm reminding the witnesses, of course, they're required to tell the truth before committee. You can be charged with contempt of Parliament if you mislead the committee. But since Confederation, nobody has ever waived parliamentary immunity to charge somebody with contempt for misleading a committee. So that's why, out of practice, the committee has not done that. But we will have a vote per Mr. Cooper's a recorded vote by Mr. Cooper, certainly, and this would apply to both witnesses.
Both.
Okay. Okay. Mr. Clerk.
Merci.
By the way, so those voting aye are voting to swear in the witnesses. Those voting nay are saying it's not necessary. Mr. Clerk.
Monsieur Boissonneau.
No.
Mr. Assassi.
No.
Mr. Fraser. Ms. Khalid.
No.
Mr. McKinnon.
No.
Mr. Barrett.
Yes.
Mr. Cooper.
Yes.
Ms. Raitt.
Yes.
And Mr. Rankin.
Yes.
Yeas pour, 4, 4, and nays contre, 5, 5.
Thank you very much. So that motion being defeated, I'm going to return to welcoming again Mr. Michael Wernick, who's the Clerk of the Privy Council and Secretary of the Cabinet. Thank you very much for coming back before us, Mr. Wernick. Et aussi à Madame Nathalie.
Also, we'd like to welcome Ms. Nathalie Drouin, who is the Deputy Minister of Justice and Deputy Attorney General of Canada. So thank you very much for being here today, Ms. Drouin.
Witness for opening statements, and we will start with Mr. Wernick. Mr. Wernick, the floor is yours. Oh, sorry. Before we start, excuse me, no time. We have Mr. Wernick's and Madame Drouin's opening statements that we have distributed to committee members. We also have the undertakings from Mr. Wernick from his last appearance before us to provide certain notes and correspondence that he had agreed to provide. We have those here. Some of them, much of it is bilingual, some of it is in English only. So I'm requesting the committee's permission to distribute it, despite the fact that some parts of it are not translated. Does the committee agree to have it distributed regardless? Everyone okay? Oui, Monsieur Plamondon?
Mr. Plamondon, I know that I can't object legally, but I'm very disappointed that we're not respecting one of the two official languages of our country fully. But I'm not opposed, since I don't have the power to do so, since I'm not a member of this committee. Mr. Beltud? Chair? This is the second time that this committee has not respected their responsibility to have documents in both official languages. We won't oppose these documents, but I would like you to inform all witnesses and members of this committee how important it is to transmit all documents in both official languages so that we can have access to the information in the language that we have the right to have access to it in. Generally, it's not the duty of the witnesses to do so. It's the duty of the clerk and the committee to translate the documents. And generally, we don't give everyone documents that aren't translated because it creates a time lag. And therefore, we asked if we were ready to distribute them for him. Chair, given the subject, I won't object. But what I would like you to do is to reiterate to the witnesses before they appear is to give us documents in both official languages, because this is the second time the committee has done this, and it would be important for this not to become a habit. Yes, we will accept unanimously to have these documents distributed It's only so that everyone can have documents in time today, but I agree entirely that we want all documents to be in both official language. That is the practice of our committee. I hope that the documents will be translated in both official languages eventually. Yes, and given to all members. Yes, just for everyone to know, when we do receive documents, it's our responsibility as a committee to translate them, and we do distribute them afterwards. Sometimes, such as today, we want to have members to have access to these documents, but yes, of course, the committee will translate them, and then they will be distributed in both official languages of Canada. So I understand, Mr. Plamondon, your concern, but I do realize that it's important today to be able to listen to the witnesses, and we have all the documents at our disposal.
Move to Mr. Wernick. We will distribute this, Mr. Clerk, and we will move to Mr. Wernick's testimony. Mr. Wernick, the floor is now yours. Thank you, sir.
Monsieur le Président,
Chair,
since I last appeared at the committee some 2 weeks ago, one is the waiver that was offered to witnesses so that will allow different lines of questioning by the committee members. And the other, apart from my cold, is the kind of traffic that I have received on social media. And I would like to present these to the committee. If somebody could please transmit them to the clerk. And I would ask
What is
the
the
committee...
relevance, point of order, what is the relevance of social media to what we're doing? The terms of reference
If I
being
could explain,
whether a line was crossed,
If
Mr.
I could
Chair?
explain,
Yep. Of course, Mr. Wernick. Go ahead. Stop time. Go.
I believe that you will want to discuss this as the intimidation of a witness before your committee and a breach of the committee's privileges. You can take that up in camera if you wish. I will be distributing these to the media.
Okay, thank you very much. Since I haven't seen them, I'm not going to say anything right now. I just asked to move back to your opening statement, and the committee will consider it at a future date or when we're ready. Thank you very much, Mr. Wernick. Please go back on time.
Thank you. So, Monsieur le Président,
Chair.
testimony to the Justice Committee on February 21st was partisan, presumably in content or motivation. I would like to respond. I would also like to provide the committee with my recollection of conversations I had with the former Attorney General. I want to first clarify my role within the Government of Canada as Clerk of the Privy Council. I am the Deputy Minister to the Prime Minister and Secretary to the Cabinet. In the first role, I'm charged with delivering advice to the Prime Minister and assisting him in delivering his agenda. I've had a close working relationship with the Prime Minister for more than 3 years, sitting in on countless meetings and discussions covering the entire range of government activity. I work at the intersection of the public service and the elected officials, and I am present for many discussions that touch on matters that some would see as political. It is my role to be aware of this context, but I do not ever give advice that is partisan in content or motivation. En tant que greffier, une de mes
As clerk, it is part of my job to give the Prime Minister impartial advice and feedback on how his ministers are exercising their roles, their relationship with colleagues, and with the public service. The Prime Minister and his staff seek my advice before cabinet shuffles, and I have been the main advisor on appointments and deployments of deputy ministers.
My job is to ensure the smooth flow of decision-making through the cabinet system. The most scarce resource in Ottawa is time at cabinet, and I work hard to ensure discussions are well prepared, due diligence is being exercised, and options crystallized so that ministers in the cabinet room can focus on the key aspects of decisions before them. Part of my job is to keep the government's agenda moving. En tant que 23e greffier,
As the 23rd clerk, I have tried to be open with Canadians about my role and my perspectives. I communicate with them through a website and presence on Facebook, Twitter, and LinkedIn. All of my speeches are posted. I have given media interviews and I have appeared before parliamentary committees. As head of the public service, I submit a report to Parliament and Canadians every year on the state of their public service. I have always tried to be direct in my language.
Disappointed to be accused of partisanship by people that have never met me. My career is on the public record. I have held the highest security clearances that this country can offer for many years. I was named to deputy minister level positions by Prime Ministers Chrétien, Martin, Harper, and Trudeau. I participated in the transition exercise, the swearing in, and the first cabinet meetings of Prime Ministers Martin, Harper, and Trudeau. I have attended more than 200 meetings of Cabinet and its committees since 1987. I have attended First Ministers' meetings with 4 Prime Ministers in the chair. I set this out because it's been suggested that I'm part of someone's political agenda. I serve the government of the day. So turning to the discussion at the Standing Committee on February 21st, my comments about the ethical conduct of the government, and previous governments for that matter, were not motivated by a desire to burnish their image. I have spent thousands of hours with politicians and political staff from all stripes, and I am in a unique position to attest to Canadians through you from personal experience that they are well served by the women and men who work in the offices of the people that they elect. Since I was last here, there have been a few developments. One is that several people have suggested I am more political than a public servant should be. I hope I've clarified that I understand my role in government. And the other development is the waiver and that the former Attorney General has testified. I will not respond to all of her evidence, but I do want to make a few points before we begin questions. My understanding is that one purpose of deferred prosecution agreements is that corporate criminality does not devastate workers, pensioners, suppliers, and others who did nothing wrong. This is in the criminal code, and it is part of public interest considerations. In speaking to the Attorney General in December, I was giving her contextual information about the SNC-Lavalin matter directly relevant to a decision she had to make. In dealing with the public interest, the Attorney General's decision is never final. The public interest can evolve and change, and the impact of a decision to prosecute or not prosecute was evolving in this case. When I mentioned to the Attorney General on September 17th that there was an election in Quebec, I did not do so out of any partisan consideration. That is an unfair inference. It is a long-standing convention for the federal government to try to stay out of the fray of provincial election campaigns and let the people of each province decide for themselves who they want to govern. In mid-September, based on the company's public disclosure obligations, I was concerned that a purely federal issue could surface in the last 2 weeks of that rather heated campaign. And it is my job to remind elected officials about those conventions. Lorsque je lui ai mentionné
On September 17th, when I mentioned that Quebec was in an election campaign, I didn't do so for partisan reasons. This is an unfair inference. It is a long-standing convention for the federal government to stay out of the fray of provincial election campaigns. In mid-September, based on the company's public disclosure obligations, I was concerned that a purely federal issue could surface in the last 2 weeks of that campaign. It is my duty to remind elected officials about those conventions.
In September and in writing in December that the decision about prosecution was always hers to take. The Premier Ministre a assuré le Procureur Général.
The Prime Minister assured the Attorney General in my presence in September and in writing in December that the decision about prosecution was always hers to take.
The cabinet shuffle was finalized, and the next day, in the context of calling 5 deputy ministers who were affected and would have to be ready by Monday, I called Madame Drouin and asked her to make sure that the new Minister of Justice and Attorney General would be brought up to speed on a number of prominent files that he would likely face questions about in the near future, perhaps as soon as the cabinet retreat in Sherbrooke which would begin on Wednesday afternoon, 2 days after the swearing-in. I mentioned carbon pricing litigation, the Norman trial, TMX, and SNC-Lavalin. I don't know if the Deputy Attorney General will agree with my recollection, but I never singled out SNC as the only issue, and it would be a misreading of my conversation with her to suggest it was. Je maintiens totalement.
I stand by my testimony of February 21st. And in terms of the testimony of the former minister on February 27th,
Testimony, the following facts are not contested. She was always the decision maker. She was assured multiple times that she was the final decision maker. The former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful. Je souligne que la suite de témoignages de l'ancien.
I would like to note that after the former minister's testimony, the following facts are not contested. She was always the decision maker. She was assured multiple times that she was the final decision maker. The former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful.
That her decision, a decision to take no action, was final in September. But she had the ability, as new public interest considerations emerged, to reassess the context and re-examine her reasoning, and that is the most she was ever asked to do. So I repeat my contention: the minister experienced lawful advocacy to consider doing something lawful in the public interest. I made no threats, veiled or otherwise, that the minister's decision would lead to consequences for her, and my position could be captured at all times by the well-known phrase, non-ingérence, non-indifférence. It is my contention the minister was doing her job, and I was doing mine. Je soutiens que la ministre remplisse.
I would like to repeat my contention that the minister the Prime Minister fulfilled his role.
Not say today. And I've been advised not to opine on the minister's reasoning or state of mind because some of the issues are or will be before the courts. So, my recommendation to the committee would be to develop an all-party report proposing improvements to the law around deferred prosecution agreements. Your recommendations could be adopted by the House in a single sitting day and become law before the end of this Parliament. This committee may also want to further explore the potential separation of the Attorney General function with a view to informing Canadians, and it would permit each party to take a clear position on this matter during the imminent election campaign. This is a profound change that could have consequences intended and unintended for decades to come and should not be rushed. Finally, this is the Justice Committee, and the committee may wish to hold hearings on the Attorney General of Canada's Directive on Civil Litigation involving Indigenous peoples, which she issued on January the 11th, 2019, effectively her last day on the job. This directive to all Government of Canada litigators could mark a profound change in Canada's legal landscape. However, it could be repealed or gutted at the stroke of a pen, and all that work turned to ashes. So I think now that all political parties need to be clear with Canadians on the future of that directive. That is my opening statement. I'd be happy to take questions from the committee.
Thank you very much.
Thank you for your patience.
Thank you very much, Mr. Wernick. We're going to turn now to